Hey guys, welcome back. Todd Vandermind here, former NRA contract lobbyist and Illinois' all-around go-to gun guy for gun laws. Today, what we have is Bianchi v. Frosh. So just a little while ago, the Fourth Circuit Court of Appeals took oral arguments on the Maryland semi-auto ban. This is one of the GVR cases from the Bruin decision. So Bruin was decided. There were 4 cases pending at the United States Supreme Court. You had the Hawaii carry case. You had the Duncan mag ban out of California. You had a mag ban out of Jersey. And you had Bianchi, the semi-auto ban out of Maryland. All of them were held onto. And then after New York was decided, they were GVRd. Granted, cert, they were accepted by the court. The court then vacated or erased the lower court's underlying anti-gun decisions against us and then remanded those courts or those cases back to the courts for them to get a do-over based on the new standards enumerated in New York. So that's where we are today. This original 3-judge panel in the Fourth Circuit was made of Traxler, Richardson, and Thacker. For whatever reason, and the history of the court had been to remand the case back to the original panel. For whatever reason, Judge Traxler was not on this panel today. Maybe he wasn't available. He's still a judge within the district, and we were hoping for Judge Traxler to be on the panel because he's been instrumental in writing good things about the 2A. Anyways, today's panel turned out to be Niemeyer, Richardson, and Thacker. So Richardson and Thacker were from the original panel. Thacker is an Obama appointee, a female judge who was just against guns, period. She made some crazy arguments during this. I will tell you that based on my read of the questions, and I sat through 2 cases prior to this. It was live streamed over the internet, and so I listened to 2 unrelated cases prior to this and try to feel out who the judges' voices were so I could kind of identify them and get a feel for their questioning, their demeanor, or they got up on the wrong side of bed. And I would say that if I have to put money down on this today, Niemeyer and Richardson are going to go with us on this case. The state, we are seeing the anti-gun politics of litigation playing out in real time. So let's go through, this is going to be a short video on just some of the talking points. I will do a deep dive into playing the state's arguments and audio at a little later date. But here, the state argues that Kobe was the original semi-auto ban challenge out of Maryland. It became, they ruled against us. It became defining precedent for the Fourth Circuit. Then Bianchi was filed after Kobe was decided, and they never really got to a trial. It was all about a motion to dismiss, all those procedural antics of this. And so there never was discovery or any of that kind of stuff. And because of that, the appellate court just said, our hands are tied based on Kobe. It's binding precedent. We're not even going to get to this other stuff. That's it, end discussion. Bianchi was then in a position to be appealed up to SCOTUS for cert. It was pending there when the Supreme Court GVR'd it, kicked it back to the appellate court. And here the appellate court, it seems that in their initial review, that they were not just going to do what the Ninth Circuit has been doing and automatically kick this back down to the district court for full-on proceedings, start all over, start fresh. That hasn't happened. These 3 judges thought they had enough. Interesting. So the state is arguing that Kobe has not been overturned. And there was a lot of debate about what Kobe's precedent value was in this. You had Justice Thacker trying to bootstrap Kobe, and they seem to be taking from the concurrence by Justice Alito, where he said that nothing in today's opinion, talks about the types of guns that are allowed. There's a short phrase in his concurring opinion, and they are trying to hang a 10-gallon cowboy hat on that thread. They're trying to do that. There's a couple of interesting things here. Understand that Kobe's standard of review was under the old two-part test, and that they also determined that since these were most likely for military use, they were not protected under the Second Amendment. So there was a lot of time going around what the test is. And here's where, if you go back to the Heller decision, at the time, the holding in Heller said it protects the law-abiding citizens' use of firearms for lawful purposes such as self-defense in the home. And all we heard out of the anti-gunners for a couple of years, and even up until just recently, up until prior to Bruin or New York, that all Heller said was handguns and in the home. They overtly, intentionally, and I don't know if it's their stated denial, that they just wanted to ignore the such as, for lawful purposes, such as self-defense in the home. There's a big difference that had they not put those two words such as in there. And so the state sat here and was arguing that while we're saying, hey, Heller says in common use is the test. There's over 20 million ARs out there. We passed the test. It is protected by the Second Amendment. And the state of Maryland, and we've seen this in California and a couple other places, they are not arguing in common use. They are arguing, because it talked in the New York decision about in common use for self-defense, they're trying to, just like in Heller, dangerous and unusual, they are trying to interject that in common use and, here's the big word, actually used in self-defense. Not that you acquired a gun for the idea of self-defense and it stayed in the corner and you never fired a shot in self-defense, but they want to say that the test is in common use, having actually been used in self-defense situations. They're trying to bootstrap the handgun comment in Heller that most commonly used for self-defense. They're trying to bootstrap that up and say that just 20 million ARs does not make them in common use. They have to be in common use and actually discharged or used in a self-defense scheme. That's what they're trying to get at. And then in lieu of that, they wanted to go down that. So Maryland's ban is typical two-part ban. A, you have a list of enumerated guns. B, you have kind of this sliding scale features test. And so they want to next go down and say, well, we don't concede today, but maybe ARs you can get to the common use on those, but not AKs or M1As or FALs or whatever else is enumerated on the Maryland list. I don't have it up in front of me, but they want to go down. They want to remand back to the lower court to go through discovery and try to argue model by model whether or not they have actually been used in self-defense. That's how far they want to go. So these are the pitfalls that we are seeing that we're going to have to avoid in litigation going forward. They are giving us the roadmap. This is an open book test, and they are giving us their playbook. And this is very, very useful. They argued that common use is not ownership. Our side got to the point and reminded them of Alito's decision in the stun gun case that 200,000 stun guns was enough to define in common use. So we're going to have an argument about in common use, how that definition of in common use should be read. We're going to have an argument, and our side should not concede that self-defense is the defining or significant factor. We should be arguing that at all lawful purposes, period, the end. That is it. In common use for any lawful purpose. Target shooting, hunting, collecting, self-defense, competition, whatever it is. Art. That's it. And the really interesting thing here is that while the judges pushed them, and they spent a lot of time on this in common use, and the state, in their arguing that Colby was not overturned, one of the judges read back the findings in Colby and then said, that's not the test. Are you telling me this military usefulness is the test today? And the state representative for the Attorney General's office did not want to get there. And we'll get to that audio. That's probably going to be 3 different videos on the state's arguments in this case. But they never even got to the second part of the test about history and any sort of debate about what the history is around. They talked about where the burden of proof falls. They spent some time saying, is the burden of proof that it's under the text of the Second Amendment fall on plaintiffs? And now then the second part of the test, what's the text and history, fall on the state? It was interesting to see how they're dissecting it. If I had to put money down or bet a bottle of Jack Daniels, I would bet that we are going to prevail on the underlying decision. I think that if they do not remand this case, and I don't think they will, I don't think they seem to push back pretty hard that they had enough information and that what kind of discovery are you really going to do? And they want to bring in their experts, and they want to take on the California model and have a vociferous debate and have their people depose our experts and vice versa and all that kind of stuff. But they never got to the history question of what the history of gun bans actually looked like. It was all, I'd say over half of it was focused on this in common use test. And that's what you have. So I would bet that we are going to prevail. They are going to slap Maryland down for what the decision is or what the test is and how in determining these things. I think we are likely to get a good reading of the New York test, because when you hear the orals on this, you'll hear how much time they spent arguing about what New York says and doesn't say. Our side needs to be a little bit more forceful in some things. Cooper and Kirk argued this case. I think Pete Patterson was supposed to, but it did not sound like Pete Patterson to me. It sounded like David Thompson. I thought our side did a good job on this, but I think we need to take the lessons learned from what the other side is arguing, shut those arguments off, be unyielding in how we're going to apply the test, and we have to have our enunciation or enumeration or delineation of those things. At the very end, this Judge Stacker started asking questions about nuclear bombs and BS like that, and I think that our simple answer is we're here for things that go bang, not boom, and we'll start there and we'll work our way backwards. But with that, thanks again. Hope this is useful and gives you a little spring in your step today, that I thought today was a good day for gun owners and our litigation teams and all that. So please hit the like, subscribe buttons down below. Our videos are getting up there. We're past the halfway point to getting 1,000 subscribers. Need that to hit the monetization part on this stuff. We'll keep making videos if you guys keep watching, please. So share this, copy and paste the link to all your social media contacts. Let everybody know. And just as far as Illinois goes, Representative Morgan, if you do not read the writing on the wall that's coming down from these judges, then you ought to turn in your law degree. You're just, this gives me a lot of heart for what we're going to do here in Illinois. So please, like, subscribe, pass this around, tell all your friends, and always, frag out.